Please welcome David A. Keene from the Washington Times, former U.S. Attorney Sidney Powell, and Kevin Ring from Families Against Mandatory Minimums. The panel will be moderated by Pat Nolan, ACU Foundation Center for Criminal Justice Reform.
Thank you. Well, that little video should send chills up your spine. Over the last several years, prosecutors have injected themselves into the political process, going after and trying to take down Governor Perry, Governor McDonnell, Governor Walker, add in Dinesh D'Souza, James O'Keefe, Senator Ted Stevens. They're assassinating our leadership politically and using the courts to do it and using underhanded tactics. As was pointed out in the Ted Stevens case, their corruption was so bad, their lies to the judge and their hiding of evidence and witnesses was so bad, the judge appointed a special prosecutor to go after them. This is a problem for all of us. If they can do that to a powerful U.S. Senator, a recipient of the Distinguished Flying Cross from his service in World War II, and a genuine hero, think what they can do to the average one of us. We're going to start with Sidney Powell, herself a former assistant U.S. attorney and an appellate division lawyer for the Department of Justice, but she was intimately involved in the defense of Senator Stevens, appalled at what she saw as the underhanded tactics used by the Department of Justice. She's written a terrific book, License to Lie, which conveniently is available here. It's chapter and verse on what they did to cheat and try to send to prison a man that was totally honorable and in the end exonerated. So Sidney, can you tell us a little of what you came across and had to deal with?
Definitely. Williams and Conley, Brendan Sullivan and Rob Carey were lead counsel for Senator Stevens. They fought tooth and nail throughout that trial, having knowledge that there were things that the prosecutors were hiding. They just knew what Senator Stevens had said and done and knew they weren't getting the full information from the government. But it was a hammer and tong fight for them throughout the trial, only to find out after the jury returned a verdict of guilty against Senator Stevens that the prosecutors had in fact hidden significant evidence that they knew directly contradicted the prosecution's case, and they should have given it to Senator Stevens. Because the prosecutor holds all the cards in a criminal case, he or she is the most powerful person in the courtroom. They are the persons who work with the agents. They're the first to investigate. They're the ones who control the charges, the publicity for the charges. By stacking charges, they can increase sentences, which Kevin will talk about, I'm sure. The prosecutor is probably the single most powerful person in our judicial system and our criminal justice system, and they have absolute immunity from any sort of suit for their wrongdoing. A prosecutor can intentionally make up charges. I mean, make them up. Our amazing president just said he hates fake news. Well, we hate fake prosecutions. And there are cases that are absolutely contrived by the prosecution where they cite statutes that don't even apply to the offenses they're charging. Then they hide the evidence that show people are innocent and proceed to send them to prison on indictments that don't even state criminal offenses.
If I could interrupt here, this is so bad that Judge Alex Kaczynski has called it an epidemic of prosecutorial misconduct, not just about the Ted Stevens case, but across the board in Department of Justice lawyers, lying and cheating.
Yes, and in the Merrill Lynch cases that I talk about in the book, I actually represented one of the Merrill Lynch executives from Wall Street who, like all of us, believed in our system, thought for sure he could just tell the truth to the grand jury and it would come out fine, everybody would understand what he'd done. And instead, he was sent to prison for a year with the judge saying, "I understand you were just doing your job that day." It turns out the indictment did not state a federal offense. The government had hidden evidence that showed he was innocent. It was so bad they had actually yellow highlighted the evidence before the trial knowing it exonerated him, and still hid it from us for 6 years. It was only by accident, through a third team of prosecutors giving me a disc that they didn't even realize had the yellow highlighting on it, that we found that evidence after 6 years. We still could not get him a new trial.
And so they literally had a roadmap of the evidence that they should have turned over and didn't. And just by mistake, they put it in Sidney's very capable hands. David, you know, you've been in this movement a long time. You've seen that we, do have tussles politically, but have you ever seen it so bad where we actually have the government focusing criminally on our people?
It's gotten much, much worse, but Sidney's cases that she cited all go to what's known as the Brady Rule. And I don't know how many people here are familiar with the Brady Rule. It doesn't have anything to do with the New York Patriots, but it does have something to do with a fair and level playing field. We have an adversarial system, and prosecutors and defense attorneys are in an adversarial system that's supposed to produce the truth. But as Ken Cuccinelli said when he was Attorney General of Virginia, the problem is that a lot of prosecutors have forgotten that criminal justice system consists of 3 words, and they forget the middle word. Because in this system, prosecutors advance professionally, and they advance politically by hanging scalps on the wall. And they go after more and more in modern cases after politically sensitive cases that get them publicity and the like. They hide evidence. This is what Judge Kosinski was talking about. Under the Brady Rule, and Clinton Bamberger, who was the attorney in the Brady case in 1963, died last year. 1963 was when the Brady Rule was adopted. It was made stronger in follow-on cases. 1963 and today, very little is done to observe that rule on the part of prosecutors or to enforce it because there are no sanctions. So what happens is that the prosecutor, if he's caught violating the Brady Rule, if he's hiding evidence, if he's making up evidence, if he's engaged in gross misconduct in the trial, the rule is that that's the judge's deal to take care of. The problem is that 80 or 90% of the judges are former prosecutors who did the same damn thing when they were prosecutors. So the estimate is that of the people, of prosecutors who've been caught abusing this, less than 2% of them have ever been brought up on charges, and the most they've received is a slap on the wrist. As happened in the Stevens case, after the judge demanded an investigation, after the judge caught them concealing evidence and making things up, they were suspended for 15 days, later put back in. That was rescinded, and the government was told to pay their salaries. The fact is that prosecutors not only exceed their responsibilities and what they're supposed to do, but, and just as importantly, they can do it because they know there is no sanction in the real world for their doing it.
Kevin?
Yeah, I'd just like to say that I think it's an important discussion to have here because prosecutors as a class are no better or no worse than bakers or teachers. There's good ones and there's bad ones. And if we were having a discussion about EPA officials gone wild or IRS agents gone mad, everyone would intuitively understand that in this room because we know power corrupts and absolute power corrupts absolutely. Mm-hmm. And so our founders had an answer to this, and that is a system of checks and balances. And right now we don't have that. We have prosecutors with unreviewable charging authority. Thanks to mandatory minimums, they have the ability to pick your sentence. And instead of politicians hauling them up to Congress or before state legislators to ask what they're doing, how they're abusing their authority, why are they doing these things, we have politicians empowering them by giving them vague statutes, very broad criminal laws, so that if you are the old expression, if you're a hammer, everything looks like a nail. If you are a prosecutor, everything looks like a crime. And we have now given you the laws and the tools to go find them. And so what we need now is to restore some checks and balances to this system.
And let me say there's a real political price that we've paid for these bogus prosecutions. By charging Ted Stevens and convicting him, although briefly, it was thrown out. But while he was convicted, he was defeated running for re-election. The man that defeated him, Begich, provided the deciding vote for Obamacare. That was the vote that tipped the scales.
Yep.
So all of us that are frustrated, it's so hard to unring the bell of Obamacare. It was those prosecutors that made that possible, that gave Harry Reid the strong hand that allowed him to pass it by exactly the votes necessary.
You know, Kevin's got it exactly right. It's the system of incentives and the way it works that creates the havoc. Years ago, I testified before Congress when there was a bill to allow DNA testing in capital cases after the conviction was secured. And I said in my testimony, I said, if I were a prosecutor and I had gotten you sentenced to death, and for $69.95 they could find out whether I was right or not, I'd want to know if I was helping kill an innocent person.
Exactly.
And a prosecutor said to me afterwards, you got that all wrong. He said, because a capital case is a huge, huge thing for a prosecutor, and the last thing he or she needs is for somebody to say a couple of years later, oh, you were wrong. They would rather the innocent person be executed than to have that in the personnel file. All of these things are part of a system that needs to be reformed so that the incentivization is changed so that, as former Attorney General Cuccinelli put it, justice can be put back into the criminal justice system.
Sydney?
I find those remarks absolutely outrageous. Any good prosecutor, and there are some good ones, wants to seek justice, not conviction. On April 1, 1940, then Attorney General Robert H. Jackson gave a beautiful, inspired speech called The Federal Prosecutor. If you Google Jackson and the Federal Prosecutor, you can read it in its entirety. But he and then the Supreme Court have said that the United States, the job of the United States Attorney is to seek justice, not convictions. And sometimes that even means that a guilty person goes free. But when you wrongfully convict somebody, you've committed multiple crimes, because not only have you taken the life and liberty of somebody who did nothing wrong, the person who did commit the actual crime is out there still doing it. You can look at the case in Texas of Michael Morton for that. He was sentenced to prison for 25 years, allegedly for murdering his wife. DNA evidence exonerated him 25 years late, while the person who actually committed the crime was out there and did it again. Michael Morton lost his son, his 25 years of his life, the best years of his life, and the prosecutor who had hidden the bloody bandana and DNA evidence and other evidence became a state court judge in Texas. All he got for Michael Morton's 25 years of wrongful imprisonment was 5 days in the county jail.
That's exactly. I don't usually do this, but I'd like to read a paragraph from Justice Sutherland in 1935 about the role of a prosecutor in our system. And this paragraph was included in the manual for U.S. attorneys at the instructions of Ed Meese when he was Attorney General of the United States.
I bet it's from Berger versus United States.
That's correct.
I literally used to keep it taped over my telephone.
And it is not in there anymore. And had those prosecutors who went after Senator Stevens had this in their minds, they wouldn't have done it. But
Right.
let me read that paragraph because it's so important historically, and it was so important to Ed Meese that he made sure every U.S. prosecutor had it above their desk as you did. And I'm quoting, "The United States Attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in a peculiar and a very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. That was important enough that Attorney General Meese made every prosecutor read it. They don't have to do that anymore. And I suspect that even when they did read it, some of them didn't take it to heart.
And Ed Meese is an example of the generational divide in prosecutors. I've known Ed since back in the first Reagan campaign in '66. And Ed had been a line prosecutor in Santa Clara County. And he said that one of the great joys he had as a prosecutor was completing an investigation and finding out someone was innocent and telling him, you've got a clean bill of health, we're not doing anything. The new generation of prosecutors says, I've invested so much time in the case, we'd better dig deeper and find something. And that's a terrible echo of what Beria, the head of the Soviet secret police, said to Stalin. You bring me the man, I'll find the crime. You target somebody and then you search to find something to charge them with. This is appalling. And also in the days of situation ethics, where there is no good or evil, there is no justice or honesty, these folks have a complete running room. Their consciences are not formed because there are no permanent values to align them. One of the key points that Alex Kaczynski makes is we have to be involved. We have to hold the judge's feet to the fire because, as they said, it's the judge in the courtroom that has to deal with this. And they have to feel the public is demanding this. So if you take the time, if you could go to our Twitter feed or to our Facebook page and like us, we'll keep you informed. ACU has developed a grassroots network of working for justice reform. And we get experts like this to work with us on how we can be most effective at protecting the average citizen. And it's wonderful of these folks to come and give their time to help educate us about this. Sydney, you also were involved in the Enron case. Any lessons from that you came across?
Definitely, and I want to back up a little bit too and tell everyone that the prosecutor who micromanaged the prosecution of United States Senator Ted Stevens, that literally changed the balance of power in the United States Senate and enabled the enactment of Obamacare, was one of the prosecutors in the Merrill Lynch case in the book, who had yellow highlighted and hidden the evidence that showed the Merrill Lynch executives were innocent. He got promoted during the Bush administration to acting Assistant Attorney General for the Criminal Division of the Department of Justice. And the other lawyers that I talk about in the book were promoted by President Obama, even though they were appointed originally as Bush Enron Task Force prosecutors. They were promoted by President Obama to his longest serving White House counsel, General Counsel, Deputy Director of the FBI, the Attorney General for the Criminal Division of the Department of Justice, who recently left, was responsible for destroying Arthur Anderson and 85,000 jobs, all for nothing, only to be reversed by the United States Supreme Court 9-0, because Anderson had not committed an offense. Most people didn't even hear about the reversal, but they heard about Anderson destroying evidence and shredding documents and being destroyed as a company, and they probably didn't even hear that 85,000 jobs were lost because of that prosecution. It was for absolutely nothing. And the Enron cases too, the whole Enron task force, every case they actually tried that they took to trial was reversed in some part, in whole or in part, for some form of prosecutorial overreaching.
Kevin?
Well, I just want to say, we started with a video that talked about political opponents and people who were disfavored and they were targeted for that reason. In this case, you see prosecutors going after corporate folks who may be unpopular at times. The problem is you may be unpopular at some point, and David knows this better than anyone else, but prosecutors have particularly gone after gun owners in a lot of cases. And in those cases, you're not always protected by a vigilant judge in the courtroom because there may be a mandatory minimum applies that takes away the judge's discretion to bring justice. There's a case in Florida that we've been following. A 22-year-old guy came out of a bar, was being harassed by a bunch of people as he tried to leave. He was with his girlfriend. He was a lawful gun owner. He felt threatened for his life. He didn't want to hurt anyone, but he wanted to remove himself from the situation. He took his gun out, he fired it straight into the air, not aimed at anyone, no one was hurt, nothing happened. It was reported by some onlookers. He was charged with aggravated assault because he scared the people who were there. Under Florida law, because he discharged a firearm during the commission of his aggravated assault, he was sentenced to 20 years in prison. Now, the prosecutor who brought those charges held all the cards. Because it was a mandatory minimum, the judge who heard that and could have otherwise understood the context and might have said, we don't want you shooting your gun, you could have hurt somebody, we're going to sanction you some way, had no discretion, and he got 20 years. I'm happy to say that FAM and the National Rifle Association actually changed the law in Florida, but it wasn't retroactive. So that guy got 20 years, he served 10 years, he's got 10 more to go. And we've got to be able to fix these things.
Well, Dave Clark made the correct point, and that is this could affect you.
Yes.
Mm-hmm. The reason that prosecutors can do this goes back to something that Pat said earlier in Stalinist Russia, bring me the person, I'll find the crime. We have so many crimes and so many regulatory crimes that involve prison sentences today that a prosecutor or the government can in fact pick you out and find something that you did that would subject you to prison time. That's just a fact. That's
Yes.
what Robert Jackson, when he was made Attorney General, warned the Justice Department about when there were far fewer crimes than there are today. So not only do you have this proliferation of crimes, many of these crimes do not require what's known as mens rea, which means that you don't have to have any intent to do anything wrong. You might not even know of the existence of the crime when the prosecutor goes after you. And that's particularly true in some of these strict liability corporate cases.
And the regulatory.
In the regulatory world. And so and one thing that I want to point out is there's a lot of talk about criminal justice reforms. To some people that means releasing gangbangers onto the street.
No.
that people shouldn't be in prison. Period. There are people who belong in prison. There are reforms that are necessary and there are reforms that are not. In the current wave of reforms, Senator Orrin Hatch of Utah said he wanted to apply mens rea to new laws. The Democratic leadership said absolutely not, because a lot of these people that they want to go after are people that they can go after as long as there's no guilty mind required, as long as they can apply these 4,500 federal laws to target somebody and go after. So you need to look carefully and ask what the motives are when somebody says what we need to do is reform the criminal justice system. The criminal justice system is as bad as everybody says it is, but the reforms that are necessary are not always reforms that will accomplish the goals that we as conservatives would like to accomplish.
And this is really a great point about mens rea or criminal intent. For millennia, it's been the basis of the law that you have to have intended to do something wrong. That was changed as we moved into the regulatory state. There are not only 4,000 statutes, federal statutes, there are tens of thousands of regulations, many of which have no mens rea requirement. The left-wing senators were so devoted to keep empowering the regulatory state that they dropped and killed the reforms of the rest of criminal law that there was agreement on, because they wanted the ability of the bureaucracy to have strict liability for businesses here in the U.S. That is how dedicated they are to it. And it is a battle royale over this. It's not a well-known issue, mens rea, but pay attention. It makes all the difference in the world. If you mislabel an orchid being shipped, that can be a violation. Think of the SWAT team raid on Gibson guitar. They were using wood approved from India for the fretboards. Well, apparently one state in India requires that the wood be worked on by Indian employees. Well, how's an American company supposed to know that? But the Department of Interior raided Gibson Guitar. You know, who knew they had a SWAT team at Interior? And the justification for no-knock raids is that people are going to destroy evidence. Well, I defy you to flush a fretboard down a toilet to get rid of it. There was no need for those armed raids, but they did. They, harassed the owner on something that clearly. Why is the Department of Interior defending Indian jobs over Americans working on the fretboards? This is insanity. But that's what's going on these days, and we need to put an end to it. We hope you'll join us in the effort to bring common sense back and say, yes, we do need prisons. Rape, robbery, arson, homicide, absolutely. But we don't need it for a lot of these other crimes. Prisons are for folks we're afraid of, not folks we're mad at.
And there are far too many crimes now, as you all have mentioned. When you think about the incredible number of statutes that we have, and then I think it's millions of federal regulations, and progressive prosecutors have been increasingly creative in their ability to take civil regulations that were never intended to have criminal consequences and pull them into criminal law through a conspiracy statute or an aiding and abetting statute, that they then imprison people for things that were only supposed to be civil violations and handled that way. It's gotten completely out of hand. But when you do think about the number of laws, remember this, God did it with just 10.
Yeah. Now, we're involved in all the states and at the federal level. If you're interested, come by our booth. We have some literature there that explains what we're doing. You can sign up. Sydney will have her books down there. I really encourage you. It was an eye-opener to me when I bought it. And we also have a session at 4:45 this afternoon to talk about our progress in the states, where in Texas we've succeeded in reserving prison beds for those we're afraid of, treated in the community with mental health and drug addiction treatment, job training, saving the cost of incarceration. It's cut $3 billion from their budget, and the crime rate is the lowest it's been since '68. So we can have common sense spending and common sense policies and fewer people in prison.
Pat,
So
can
David.
I say something? Yes, that's an important session this afternoon. We as conservatives in this area have a great deal to be proud of, because most of the traction on real prison and criminal justice reform has not been at the federal level during the Obama years. It's been at the state level. The heroes of criminal justice reform are people like Mary Fallin in Oklahoma, Rick Perry when he was governor of Texas, Nathan Deal in Georgia, Matt Bevin in Kentucky. Republican governors who have looked at the system and looked at it with the dual vision of what is the purpose it's supposed to serve and how do we make it serve that purpose and not be subject to the kinds of abuses that none of us as conservatives think government should be involved in. So there are real heroes out there. We as conservatives deserve some credit for what we've been able to do, and there's much more that we can do in a positive sense to improve a system that desperately needs improvement.
Yep. And we hope you'll join us. So thank you so very much. And if you've liked this panel, write to Matt Schlapp and say, hey, I love having criminal justice reform on the program. All right, thank you so much.
Thank you all so much for being here.